All right, here we go. First person I have is Sheila Irene Stravisky. Are you Sheila Irene Stravisky?
Yes, ma'am.
Okay, this is case number 24T00628FY, people of the state of Michigan versus Sheila Irene Stravisky. And counsel, go ahead.
Aaron Kevin Rush appearing on behalf of Ms. Stravisky. I interviewed her this morning. We went through her trial rights, including the rights to a preliminary examination within 21 days. She tells me she understands both and is waiving any further reading of it. She's a caregiver, less than 20 hours a week, so she's asking for court-appointed counsel.
All right, thank you. Ms. Stravisky, your attorney just stated that he did go over the charge in this complaint, the maximum possible penalty for that charge, and all of your rights. Do you need me to read any of that to you again?
No, ma'am.
You know and you understand all of those things?
Yes.
I waive the reading of the charge, the maximum possible penalty for the charge, as well as Ms. Stravisky's rights. As both she and her attorney have indicated, she knows and she understands those things, and she does not need me to read them to her again today. We will enter a not guilty plea on her behalf, and we will set this matter for a probable cause conference as well as a preliminary examination. I will appoint court-appointed counsel as requested. And Attorney Rush, what would you like to say in regards to bond?
She's indicated the address is correct. She's been there for over 10 years, resided in Genesse County for over 10 years with her children. She's not on probation or parole, no prior felonies, had a retail fraud, she believes, around 2017, and a driving while license suspended case. I've advised her to have no contact with Walmart, any Walmart whatsoever. It's not a violent matter. It's a taking of a cell phone, it looks like. I'd ask for a personal recognizance bond.
All right. Okay, I'm going to set a $10,000 personal recognizance bond. Ms. Stravisky, while you are on bond with this court, you are not to use any alcohol, any recreational marijuana, or any illegal controlled substances. You are not to possess or purchase any firearms or any other dangerous weapons. You are, as your attorney told you, you are not to go back to Walmart, and if there is a specific victim in this case, a specific person who they discovered that cell phone belonged to, you're not to have any contact with that person either. That looks like a Mr. Ostrander. You have to have any contact with that person. All the other general bond conditions will apply. Next court date is probable cause conference on April 11th, 2024 at 11 o'clock a.m. Preliminary examination date is set for April 16th, 2024. Those are both in front of Judge Bea Haley, and the circuit court judge appears to be Judge Newblatt. Anything else today, Attorney Rush?
No, thank you.
All right, thank you. All right, ma'am, you're all done. You can go.
Thank you.
Good morning.
Good morning. Are you David Patrick Farmer?
Yes, ma'am, I am.
It's case number 24T00633 FY, people of the state of Michigan versus David Patrick Farmer. Attorney Rush, go ahead.
Okay.
Aaron Kevin Roth on behalf of Mr. Farmer. I interviewed him this morning. We went through his trial rights as well as the rights to a preliminary examination within 21 days. He tells me he understands both and is waiving any further reading of it. He's on Social Security disability, only gets $500 a month, so he's requesting court-appointed counsel.
All right, thank you.
Please.
Your attorney just stated that he did go over your charges with you, the maximum possible penalties for those charges, and all of your rights. Do you need me to read any of those things to you again?
Sure, you can, ma'am.
Well, it's not whether or not I can or I want to. Do you need me to read them to you again?
Yes.
Would you
Mr.
like?
Farmer, I'm sorry, don't mean to interrupt.
No, you can go ahead, Attorney Rush.
Mr. Farmer, you and I went through the charges. You told me that you understood everything, right?
Yeah, I do understand them.
All right.
Good.
All right,
Yeah,
good.
so I'm sorry.
Okay.
So, Mr. Farmer, if you understand the charge and the maximum possible penalty of those charges, do you need me to read them to you again or not?
No.
All right, you understand those things, is that correct?
Yes, ma'am.
Do you understand all of your rights today that Attorney Rush went over with you?
Yes, ma'am.
You need me to read you your rights again?
No, ma'am.
And I waive the reading of the charges, the maximum possible penalties for those charges, as well as Mr. Farmer's rights, as both he and his attorney have indicated. He knows and he understands those things, and he doesn't need me to read them to him again this morning. Whether or not guilty on his behalf, and we will enter not guilty plea on his behalf, and we will set this matter for a probable cause conference and a preliminary examination date. I will appoint court-appointed counsel, and I didn't say that on the last file, but obviously for the last file as well. I will appoint court-appointed counsel. And Attorney Rush, what would you like to say in regards to bond?
Yes, Your Honor, he's indicated the address is correct. This is his wife of 13 years. He's a little emotional this morning. He hasn't gone through this before. He is on the Social Security disability. She apparently is no longer at the marital home. He's not on probation. He's not on parole. Said he has no prior felonies or misdemeanors except for a driving while license suspended. He actually went up to the police department when she had gone up there. He went up there and was arrested as a result of this. I've advised him he can have no contact. He's never had a domestic violence case, but still, apparently this involves throwing a bucket. I'd ask the court to grant him a personal recognizance bond. He's certainly going to make his court dates.
Yes, sir.
And he does not want a divorce.
No, I do not. My first time ever being married. I'm so ashamed of myself.
Right, Mr. Farmer, okay.
Remember, Mr. Farmer, as your attorney already told you, anything you say can and probably will be used against you in court. So making statements like that, I know you mean well, but it might not do you very much good. So just be quiet for now. I'm going to set a 1, 2, 3. I'm going to set a $10,000 personal recognizance bond as to each count. There are 3 total counts, so it's a total of $30,000 personal recognizance bond. Mr. Farmer, while you are on bond, you are not to use any alcohol, any recreational marijuana, or any illegal controlled substances. You are not to possess or purchase any firearms or any other dangerous weapons or ammunition. At this point, because this case is ongoing, and I understand what your attorney has told me, but he's right, at this point, you are to have no contact whatsoever with your wife, and that means no contact at all. You can't call her, you can't text her, you can't use social media, you can't go to the home if she is there. I assume you two live together, and if she's staying in the house, I will to go to the home one time with a police escort to retrieve your belongings, but while this case is going on, you're going to have to find somewhere else to stay. You also cannot have third parties make communication or make contact with her for you. So if you have other family members trying to send her messages for you or anything of that nature, that would also be a violation of your bond. Do you understand that?
Correct. Yes, I do.
All right. All of the other general bond conditions will apply. I'm trying to think if I'm going to. I'm also going to order, Mr. Farmer, I want you to have an evaluation at GHS. I want you to have a mental health evaluation. So GHS mental health evaluation and follow all of their recommendations, whatever they may be. They may say that they don't think you need services. They may think you do, but whatever they say they think you need to do that. Do you understand?
Yes, I do.
All right. In the long run, that'll help you, that'll help your wife, and if you intend on not getting divorced, it'll probably help your marriage. All right, probable cause conference will be on April 11th, 2024 at 1:00 p.m. Preliminary examination date is set for April 17th, 2024. Those are both in front of Judge Manley, and Circuit Court Judge is Judge Lachana. Anything else, Attorney Rush?
No, thank you.
Thank you. All right, sir, you're all done. You can go.
Thank you, ma'am.
You're welcome. I can't. Lewis Anthony Ford. Are you Lewis Anthony Ford?
Yes, ma'am.
It's case number 24T00632FY, people of the state of Michigan versus Lewis Anthony Ford. And Attorney Rush, go ahead.
Kevin Rush, on behalf of Mr. Ford, I interviewed him this morning. We went through his trial rights as well as the rights to a preliminary examination within 21 days, and I read the charges to him, including the potential fine and punishment. We did also go through an habitual offender notice as well. He tells me he understands his rights and the charges and is waiving any further reading of it. He's not working, so he's requesting court-appointed counsel.
All right, thank you. Mr. Ford, your attorney stated that he did go over your charges with you, the maximum possible penalty for those charges, as well as all of your rights. Do you need me to read any of that to you again?
No, ma'am.
You know and you understand all of those things?
Yes, ma'am.
I waive the reading of the charges, the maximum possible penalties for the charges, as well as Mr. Ford's rights, as both he and his attorney have indicated. He does know and understand those things. Does not need me to read them to him again this morning. We will enter a not guilty plea on his behalf, and we will set this matter for a probable cause conference and a preliminary examination date. And based on what Attorney Rush said, I will appoint court-appointed counsel. And Attorney Rush, in regards to bond, I will note, and I believe you probably know this, but if not, I will note that Mr. Ford appears to be on probation.
Yes, Your Honor, that's true. The address is correct. That's the address of his brother, although he indicates he's actually living with the complainant and still has clothes and furniture over there. But I've told him he can have absolutely no contact with her. That's something he should discuss with his attorney. He's indicated that he is on the probation with Judge Newblatt. I'm not sure whether or not there is a hold. He is in school right now. I've advised him again, no contact whatsoever with the victim, despite what he may think that he was living there still. He can't go over to the house. I'd ask the court to consider personal recognizance bond, perhaps even with tether. And again, I am not sure whether or not there's a hold on him through Judge Newblatt's case.
All right. All right, so Mr. Ford, you need to understand that even if I decided to let you out today, and I'm not 100% sure what I'm going to do yet, but if I decided to let you out on a tether, you may have a probation hold, and so you might not be going anywhere no matter what I say today. You understand that?
Yes, ma'am.
I also want to let you know that if the address that we have on file is your brother's address, but you're telling your attorney you live with your girlfriend, then you're probably going to have another probation violation because you have to keep your address updated with your probation officer. You can't tell your probation officer you're living one place and then live another place. So don't say anything about that because I don't want you to incriminate yourself in any way, but I wanted to let you know that it's a problem.
Okay, ma'am.
All right. As far as bond goes today, let me just. Oh, so currently Mr. Ford is on probation for witness intimidation and a second felony charge as well. That does not make me feel very good about this case. I am going to set a he does have habitual offender fourth offense notice. Great. All right, I'm going to set a $20,000 10% bond on count 1. $10,000 10% bond on count 2. $5,000 10% bond on count 3 for a total of $35,000 10% bond on this case. If Mr. Ford is released, if he doesn't have a probation hold, he most definitely is to be placed on GPS tether. He is also to check in with our pretrial. Well, no, that's not necessary because he's on probation. Placed on GPS tether and he is to follow all of his current probationary terms. I am sure those terms include, Mr. Ford, that you're not to use any alcohol, recreational marijuana, or any illegal controlled substances, and that you're not to possess or purchase any firearms or any other dangerous weapons or ammunition, but we're going to go ahead and put that on this bond order as well. Any further violation of your probation will be a violation of this case. Do you understand that?
Yes, ma'am.
You are to have absolutely no contact whatsoever with the alleged victim in this case. And when I say no contact, I mean no contact. You can't call, you can't text, you can't use social media, you can't think you can use something like Snapchat and the court won't find out about it. We know how to find out when people use those things. There is always a record. You can't have third parties send messages for you or anything of that nature. Do you understand what I'm saying?
Yes, ma'am.
Your attorney stated that you maybe were living with this person, but you weren't supposed to be living there, so I'm not going to give you permission to go to that home for any reason because you shouldn't have been there in the first place.
Yeah, I promise you, ma'am, I will not go back there.
All right. And let's see. All the other general bond conditions will apply as well. There'll be a probable cause conference on April 11th, 2024 at 1:00 p.m. Preliminary examination date is set for April 17th, 2024. Those are both in front of Judge McCabe. Circuit Court Judge is Judge Christensen. Anything else, Attorney Rush?
No, thank you.
Thank you. All right, sir, you're all done. You can go.
Okay, thank you, ma'am.
Welcome. Mason Russell?
Russell. In group on your left.
Are you Mason Charles Russell?
Yes, ma'am.
Case number 24TB00631FY. People of the State of Michigan versus Mason Charles Russell and Attorney Rush.
Your Honor, Kevin Rush on behalf of Mr. Russell. I interviewed him this morning and we went through his trial rights, including the rights to a preliminary examination. I also read the charges to him, including the potential fine and punishment. He tells me he understands it all. He's waiving any further reading of it. He's not working, so he is requesting court-appointed counsel.
All right, thank you. Mr. Russell, your attorney stated that he did go over your charges, the maximum possible penalties for your charges, as well as all of your rights. Do you need me to read any of that to you again?
No, ma'am.
You know and you understand all of those things?
Yes, I understand.
I waive the reading of the charges, maximum possible penalties for the charges, as well as Mr. Russell's rights. As both he and his attorney have indicated, he knows and he understands those things and does not need me to read them to him again today. On our not guilty plea on his behalf, we'll set this matter for a probable cause conference and preliminary examination. I will appoint court-appointed counsel as requested. And Attorney Rush, what would you like to say in regards to bond?
He is 19 years old. He's indicated the address is correct. He's been at the same address his entire life, so he's a lifetime resident of Genesse County. Not on probation, not on parole, no prior felonies. Thinks he had an illegal entry misdemeanor maybe in 2022 or 2023. He would qualify for HIDA, and I've gone through that with him. The reason that I do that is to advise him that potentially he has an opportunity here, but he needs to mind his bond conditions, so he will never get that possibility of being on homes. I think he understands it. I would ask the court to consider granting him a personal recognizance bond, and I've advised him to have no contact at all with any of the individuals, including his co-defendant in this case.
Okay. All right, thank you. His prior 2023 misdemeanor was actually a larceny charge that he pled guilty to, which, look, we have another larceny charge here. And breaking and entering a vehicle. All right. The pretrial services department is recommending tether and drug testing, and I think both of those things are a very good idea. And so I'm going to follow their recommendation. Mr. Russell, I am going to let you out on a tether today, so long as you are able to provide the correct information to the tether department. But please be clear, when I say I'm going to let you out on a tether today, if you violate your tether provisions in any way, if you violate your bond in any way, if you have a problem with keeping your hands off of other people's stuff, I will make sure that you end up right back in jail and you wait for this case to play out while you're sitting in that yellow jumpsuit. Do you understand what I'm saying to you?
Yes, I understand.
I'm going to issue a 5. $10,000 personal recognizance bond as to each count. There are 5 counts, so that comes to a $50,000 personal recognizance bond. While Mr. Russell is on bond, he is to be fitted for a GPS tether. He is to be on a curfew, which means he is to be into his house he's going to be in his home between the hours of 7 p.m. and 7 a.m. every single day. He is to check in with our pretrial services department as well. He is to submit to random drug and alcohol screens. Mr. Russell, I shouldn't have to tell you that you're not to use any alcohol, recreational marijuana, or illegal controlled substances because you are too young to be using any of those things to begin with. But we are going to make you do screens to make sure you aren't doing any of those things. You are to have absolutely no contact with any of the victims in this case, and you are to have no contact whatsoever with your co-defendant. Is your attorney Rush, is your client working?
No, I don't believe so. He's indicated he's not.
Okay, that's what I thought you had said, but it went out of my mind already. All right, and Mr. Russell, you are going to gain and maintain appropriate employment as well. Maybe that will put a little bit of money in your pocket and you won't have to take other people's stuff.
Would I be able to, how would tether work with getting a job? if I can't go 7.
Do you really think that when people are on tether, they're not allowed to work? I didn't put you on house arrest, I put you on tether. Don't say anything else. You absolutely can get a job and maintain a job while you're on tether. Don't worry about it. They'll figure it out. I'm irritated a little bit that you have a problem with me telling you you gotta get a job, but not a problem with me putting you on tether. Don't say anything. All right, your next court date is probable cause conference on April 11th, 2024 at 1:00 p.m. Preliminary examination date is set for April 17th, 2024. I didn't say it, but all the other general bond conditions will apply in this case, of course. And those court dates will be in front of Judge Manley, Circuit Court Judge is Judge Christensen. Anything else, Attorney Rush?
No, thank you.
All right, you're on, Mr. Russell.
All right, thank you.
Welcome.